Hi there, it's Tara Lucke from the Art of Estate Planning, and I wanted to bring this video to you because we have had a pretty interesting decision about gift and loan back arrangements come out of the Queensland Supreme Court. The decision is Re Permewan No. 2, 2022 QSC 114. I'll put the link in the chat comments. And yeah, it's a pretty interesting decision. And we don't often actually get decisions about gift and loan backs. So I really wanted to bring this to you. I know a lot of you might have clients who are considering implementing this, have implemented this. You may even have implemented it yourself. It's relevant for a lot of professional advisors. So let me tell you about the case. I want to set the scene a little bit before we dive straight into this case. So there's usually two purposes about why you might implement a gift and loan back arrangement. Firstly is for bankruptcy asset protection. So making sure assets that might be held in an individual's name are actually not available to satisfy a claim against them by a creditor. The other option or purpose where I see this coming up is in a succession planning context, particularly in states where they don't have notional estate. So New South Wales obviously has the notional estate rules. So in Queensland, where this decision was held, and that's my home state, it's something that we look at to try and shift assets out of the challengeable pool away from a testator's residuary estate, basically. So a gift and loan back is typically used in any scenario where you want to implement a transfer of equity and assets without triggering tax or stamp duty. I'll just do a really quick demo about how that might work. So this is me. And let's say I set up the Tara Family Trust. I've got a house and it's worth 2 million, and my equity is, let's say my equity is worth 1 million. Lucky me, right? So I'm worried about my equity of $1 million in my house that I own in my own name. I'll just say, so I've got my $1 million equity. I owe the bank, let's say I owe ANZ $1 million. I run a business. I run the Art of Estate Planning. I'm worried that if something goes wrong, I could get sued and my $1 million equity is gone. So gift and loan back could be implemented like this. I set up a passive low risk family trust and I gift $1 million to that trust. The trust then turns around and gives that money back, but not as a gift, as a loan. And it should take a mortgage over that loan amount as a second priority in this case. So the trust would have the second priority mortgage. The bank at ANZ would have the first priority mortgage. And suddenly, if there's a claim against me by a creditor, someone watching this video probably, no, I'm kidding, and they want to, there's a judgment against me and they want satisfaction of that judgment, they'll say, great, you've got to sell your house. All right, well, what happens is the first $1 million, say that we get $2 million for sale of the house. The first $1 million goes to ANZ, satisfies their first mortgage. The second $1 million of those sales proceeds actually goes into the family trust. Creditor has got nothing left. There's actually nothing left to satisfy that creditor. I've sold my house, very sad, but my $1 million is in a passive trust that I might control or someone close to me might control. So I've been able to shift the equity, my $1 million equity, into a protected environment like a discretionary trust. And because that asset has remained owned by me this entire time, there's no tax or stamp duty issues. I haven't created a stamp duty bill because I haven't transferred the property. I still get the principal place of residence exemption on my home. That was before I had to sell it. And there's no tax issues about selling it. So this is how these arrangements generally work. Let's have a look at the case. Oh, I'm jumping ahead. So when you're implementing one of these, it is really important, and it has always been important, that it's been documented appropriately and full consideration has been given to all of the requirements. So when I say here consideration, I'm really talking about the money. Going back to this example, the gift of $1 million and the loan back of $1 million is critical. So it has always sort of been held that best practice is that bank accounts show $1 million leaving my bank account and hitting the trust bank account, and then leaving the trust bank account and hitting my bank account back. Often people don't have that much cash lying around. And so this is where they come up with like other ideas and ways to document that consideration. But this is, and we're going to talk about this in this moment, but in this case, but yeah, a flow of funds supporting the consideration of the arrangement has always been really critical. So has contemporaneously documenting the arrangements. So you need gift documentation, a loan agreement, mortgage agreement, registering the mortgage. If a financier already has a mortgage over the property, then needing to consent that. For bankruptcy purposes, you've always had to prove that at the time of implementing it, you are solvent. I will just say for bankruptcy purposes as well, if you don't have a dominant purpose of defeating a known creditor, then there's a clawback period of 4.5 years from the date that it's implemented. So if the creditor comes within 4.5 years of this being implemented, the whole thing can be unwound. The other thing is also they always want to look at your purpose. What was the dominant purpose of implementing this or not? Was it to defeat a creditor? So let's have a look at what this decision held. It is a really interesting decision because we haven't had these types of arrangements given a lot of scrutiny in the past. So it is really exciting to see what a court thinks about them. Okay, so in this case, we had our testator who passed away, Prudence. She had 3 children, Scott, Donna, and Marla. And Scott was her favored son. She wanted to leave all of her assets to Scott's benefit, pursuant to the will, and she nominated him as the executor. And the intention was that she wanted to try to defeat a claim against her estate by Donna and Marla. So she engaged Cleary Hall solicitors in Brisbane, and they came up with the gift and loan back arrangement. They call it a security strategy, I think. So this is actually number 2. I'll just give you a little bit of context. This is the number 2 decision because number 1 was all about Scott being removed as executor because Donna brought an application to say, well, what happened here with this gift and loan back arrangement? And Scott was saying, it's fine. It's a valid arrangement. And I'll show you why he was saying that. Because under Prudence's will, so she had a home, shares in Zalarina, which was corporate trustee of the Lotus Trust, shares in another company, and which owed her $876,000 and a right to receive $876,000. And she gave her shares in the company to Scott, and she gave the rest of her assets to the Lotus Trust. So the end result was Scott as executor was controller of the Lotus Trust, which received nearly all of Prudence's assets besides the shares in the corporate trustee. So Donna's going, okay, why does the Lotus Trust, why is there no equity in the estate? The estate should be worth $3 million, but it's actually worth $0. So I can't bring a family, or if I brought a family provision application, there's no point because there's nothing in the estate. So Donna wanted Scott to challenge the validity of the gift and loan back. And of course, he had a conflict of interest. He's not interested in doing that at all because it would undermine the assets that he was receiving. So the first proceedings of this basically said, yep, Scott can't be executor anymore. And they appointed an independent administrator. Okay, so number 2 was all about, before Donna and Marla look at bringing a family provision application, what's the size of the estate? Does the gift and loan back stand? Okay, so let's talk a little bit about what happened. Okay, this is back when Prudence owned, I don't know for sure, but I think Prudence was the sole shareholder. Oh yeah, we do know that because she owns the shares. So Prudence was the sole shareholder and director of Zalarina. So she held everything in her own name, and the whole idea was to get the equity, the $3 million estate equity pool, into the Lotus Trust so that it could go to Scott's control and her estate down to 0. And she could have just transferred her home into the trust or to Scott, as well as those other assets, but that would have cost a fair amount in stamp duty. She would have lost her principal place of residence exemption over the home, and she also would have lost control of those assets during her lifetime. So the gift and loan back was a way to achieve that without triggering those those transaction costs. So how was this done? Firstly, she made a statutory declaration saying that all payments made by cash check or bearer promissory notes to the Lotus Trust are by way of a gift. Okay. She then entered into a bearer promissory note, or created a bearer promissory note, where she promises to pay the holder of the note $3 million. Zalarina, as trustee of the Lotus Trust, had a record saying that it received that note from Prudence. So it received the right to receive $3 million as a gift. Then Prudence actually received that back from Zalarina, but that came back as a loan. So she's like, I give you this note where I pay you $3 million. And then in her capacity as sole director of Zalarina, they then go, okay, I give it back to you and I'll pay you $3 million, but it's a loan this time, not a gift. And then there was acknowledgement in the promissory note that it was cancelled by Prudence because of the merger of the right to be paid and the obligation to pay. You can see the difficulties it presents when you explain it, even when you just say it out loud. Okay. There's then a resolution by Zalarina Proprietary Limited as trustee of the trust. It acknowledges that it received the bearer promissory note and that it has decided to lend money gifted by the promissory note to Prudence, repayable on demand, and that it will execute a loan agreement and mortgage. So then it goes ahead and there's a loan agreement to record the loan. So Prudence now owes Zalarina as trustee for the Lotus Trust $3 million, payable on demand, and it is secured by a mortgage. Then she also assigns, so Orion Investments was a company that owned like a commercial property, and it owed her $870,000, maybe by like unpaid distributions or income dividend or something. So maybe it was a bucket company, I don't know. So Prudence assigned the right to receive that $870,000 to Zalarina as trustee for the Lotus Trust. So we ended up with the situation where Prudence owes the trust $3 million, and I'm pretty sure there was now a mortgage over this property in favor of the Lotus Trust. What did the court decide? So single justice in the Supreme Court of Queensland looked at these factors. It was relevant that Prudence did not have $3 million in cash. So she made that gift with the bearer promissory note, but to actually enact it, if it had been called upon, she would have had to sell up everything. And that was really relevant. It also looked like her purpose was just to defeat a family provision application by her daughters. So there seemed to be evidence saying that the purpose was to avoid any tax or stamp duty liability. But I think that's a bit confused. And maybe, I mean, I'm just reading a judgment. I haven't seen the full transcript, because it's like, well, actually, your purpose was to transfer assets and you did it by the gift and loan back security arrangement because you didn't want to pay tax or stamp duty, but the underlying purpose is to remove assets out of your challengeable pool on your estate. There was also some timing issues, which I tried to piece together to do with how things were conducted with the solicitors. And there was some issues, I think, with how the evidence was initially presented and then what was revealed on cross-examination. So, for instance, from a timing perspective, Prudence signed the documents in a meeting on the 12th of October with the accountants and the lawyers. But Zalarina was not the trustee of the Lotus Trust then. Okay, that company didn't become trustee until a month later. But these documents were all about, like, if we go back, when they were signed, Zalarina has received the promissory note. It's been delivered to Zalarina. Zalarina didn't even exist then, I don't think. Let's just actually check that. Okay, I just did a quick ASIC search. Yes, so Zalarina wasn't registered until like mid-November 2017. So Zalarina did not exist at the date of this meeting when the documents were purported to have been signed. And the evidence was that they were signed but not dated and held by the solicitors until the 18th of April, where Prudence directed them to sign the document. So it's like, when were these even signed and how were they created? I'm actually thinking through even the practicalities, because I'm imagining like turning up at a meeting and then I don't have an ACN, I don't have anything. So how have I drafted these documents? So it's a little bit unclear, to be honest, and that did not serve them well. Okay, so what was held by Justice Cooper? It was an illusory transaction and a sham, were some of the words described to set aside the effectiveness of the gift and loan back arrangement in these circumstances. They found that the bearer promissory note had not been delivered to Zalarina as trustee for the Lotus Trust, and absent delivery of the promissory note, the transaction remained incomplete. So delivery in this situation was really important to that consideration element, which I mentioned at the beginning. They also really scrutinized the fact that Prudence controlled Zalarina. So they said that this really meant that there was no prospect that the loan would be called on by Prudence during her lifetime. They really relied on that evidence to say that that there was just no intention for this ever to be executed, and that the intention behind the loan and the mortgage was a sham. So yeah, that was really, it's not a surprising outcome, really. Even though we should have a separation of a legal entity where Zalarina and the trust, the corporate veil is there, it's a totally separate entity. The fact that Prudence totally controlled it and she did not have access to $3 million meant that if this transaction was to be relied upon, she would have to sell everything. And there was just no intention to do that, particularly because there was no there was no evidence around this being done for bankruptcy protection, anything like that. They also talked about the public policy rules relating to Succession Act. So Section 41 is the section which gives the other daughters, Donna and Marla, the right to bring a family provision application. And basically that the whole purpose of this was to defeat or circumvent the right for them to bring an application. And they looked at this and said that it would be against public policy to hold that this transaction was effective. So that's interesting. I don't think we've really seen anything like that coming out about a decision. This is the first decision I've seen about this type of agreement in the context of defeating a family provision application. I'm just looking through the judgment. And it's a single judge, and they kind of say, this is exactly what they say. In the circumstances, I am confident that the administrator was almost certain to have succeeded on his application on the basis that enforcement of the transactions would be contrary to public policy. So I don't know if the way that is worded is just not going quite far enough to say that the transaction is against public policy, or if I'm just really picking at words, but we're on notice, right? We're really on notice. So what does this mean for gift and loan backs? Yeah, I think for practitioners looking to implement this from a succession planning strategy, we're really on notice now about this public policy rules, that is probably against public policy, and that's a way that someone can attack this. The sham argument, I mean, it's always been there because it's very your left hand dealing with your right hand, and I would have loved to have seen a scenario where it wasn't quite as problematic. I really always want to see like cash coming into bank accounts. That said, not everyone usually has the full sum. So sometimes you do like payments by installments and you're cycling the same sum of cash through a few times, which again looks a little bit, if it smells fishy, it probably is fishy. So, but I do think the issues with the dating of the documentation happening and the signing happening before the corporate trustee was appointed and registered, the fact that there was no consideration with the bearer promissory notes, that it was not delivered. I do think that those clearly make this on the spectrum where it was much easier to say it was a sham. I also think, when we're looking at this from succession law to Bankruptcy Act protection, they're different tests. The rules are really different. We've got the clawback rules that apply under the bankruptcy provision, and we've just got totally different tests here. So I think I will be much more cautious about implementing this in a succession law perspective. In a Bankruptcy Act, I think this doesn't help the robustness of the strategy, but it is an entirely different context, different legislation, and a different test that we've looked at here. So I will just say, for instance, I'm looking at implementing one of these myself, but on a new purchase. And so I think like that type of arrangement is probably a lot less risky, where, for instance, if I want to buy a house and I'm over here with money in my bank account, I might settle that in a passive trust first and then use the trust to contribute my equity into that property purchase as I buy it, all happening contemporaneously, actual money going from my bank account to the trust bank account and then to the vendor's bank account to create my equity. And rather than, when you buy a house, you would just buy it. So this would be a gift or a settlement into the trust, and then the trust would loan that sum into the purchase pool. So obviously I'm going to be having a bank contribute some of my money, I'll be contributing the rest. So I think in that situation, if it's all happening contemporaneously as the transactions are happening, the money is flowing, I would feel that this loan holds up a lot better. You'd probably want a second mortgage too, after the banks. And so I do think, that type of arrangement or way to execute these concepts still works. And that's for bankruptcy perspective. I'm not trying to defeat any family provision application as well, but I am increasingly nervous now about what this looks like for defeating a family provision application. I probably would stop recommending it for my own clients until we see what happens if this gets appealed or not. So yeah, I thought that was really interesting. It's exciting to see this type of decision come out. These are just my preliminary thoughts. I've just read the judgment today. I'm interested to hear what others are thinking too. But yeah, I thought I would share that out. If you have any comments, questions, feedback, please let me know. Thanks so much for watching.